Good morning, good afternoon, everyone. It's so good to be here and to be here with you all today. Thank you for joining us today as we are uh, going to be discussing criminalizing coercive control. My name is Angela Marie McDougall, and I'm the Executive Director at Battered Women's Support Services here in these unceded ancestral territories of the Squamish, Tsleil-Waututh, and Musqueam people. And we've got an amazing conversation to share with you all today. And I'm so grateful that you all came from coast to coast to coast. We had just an incredible response to the invitation, and we have a powerhouse group of advocates and visionaries and knowledge keepers here today to talk about their perspectives on what it means to contemplate criminalizing coercive control. I would love to kick it right now to my beloved colleague, Summer Rain, who is the manager of the Justice Center at Battered Women's Support Services. Hey, Summer.
Good morning. Tanaik Hootstugwe Jahadi Hino Dikyong. My traditional Hada name is Strong Grizzly Bear Woman. My English name is Summer Rain. And I just wanted to take a minute to open and acknowledge that from our end, we're gathered on the unceded Coast Salish territories of the Squamish, Musqueam, and Tsleil-Waututh nations, and to give my thanks, honor, praise, appreciation for being able to live, work, and play on these beautiful unceded territories. I know that we have people joining us from all over, so you are on different territories, and I welcome you into our Zoom space on our unceded Coast Salish territories here. And appreciate you taking the time out of your day to join us for this very important conversation about the impacts of coercive control and the survivors that we support on a daily basis. Hawa or Haishka, thank you.
Thank you, Summer Rain. Yes, this webinar, as we've envisioned it, does invite this discussion and input on what the potential impacts could be for the pending legislative changes, as well as options for post-legislative policies and practices if we get there. And I would love to just acknowledge the fact that we have Lucy and Lonnie from Battered Women's Support Services who are behind the scenes helping us out today. Hey, Lucy. Hey, Lonnie. You've probably heard from Lucy in an email, and she's doing an amazing job getting us going today. We have had a bit of a change today that so far Agnes Wong has been unable to join due to some technical challenges. We're hoping that she could join, and if she does, she might jump on, which will be great. We are planning to run a poll today at the beginning of the webinar and then near the end with the question of should coercive control be criminalized? And you're welcome to share your responses through that poll. And I'm so happy to introduce our wonderful panelists. First, Emily Coyle, who, as you probably noticed in the webinar and the website information, is the Executive Director of the Canadian Association of Elizabeth Fry Societies. I'm so grateful for you joining us here today, Emily. And Pamela Cross, of course, who is the wonderful Canadian feminist lawyer and women's advocate, well-known expert on violence against women and the law. Hey, Pamela, thanks for being here. Agnes, we got our fingers crossed that she's gonna join. Deepa Matu, hey. Deepa is the Executive Director of the Barbara Schleifer Commemorative Clinic and an accomplished lawyer and intersectional feminist. So glad you're here. Thank you. And then, as I mentioned before, Summer Rain, who is our manager of the Justice Center at BWSS, doing great work with our team. And anti-violence and gender justice organizations continue to discuss and debate whether and when, frankly, it's wise for women victim survivors to use the state and when it's dangerous to do so. And there are a number of reforms being contemplated. You probably know that the Ombudsman for Victims, the Federal Ombudsman for Victims, is right now taking a look at the sexual violence and criminal law. And here in BC, the Attorney General has started a review of the criminal law as it relates to intimate partner violence and sexualized violence with Dr. Kim Stanton. So the kind of contemplating reforms continues, and I think as we're perhaps leading into election time, and with criminal justice, criminal legal issues are front and center in all kinds of ways, and how those interface with gender-based violence is ever present. And the impetus to criminalize this form of intimate partner violence known as coercive control appears to be forging ahead in Canada after members of Parliament voted unanimously in support of a private member's bill from New Democrat MP from Victoria, just off the way here, Laurel Collins. And so Bill C-332, proposed law, passed, I believe it's third reading in June last month, and was endorsed by all 4 major federal parties. And it really, I think, sets up Canada to follow in the steps of Tasmania, the UK, England, Wales, Scotland, and several US states that have criminalized coercive control. And in Canada, I think there's probably 2 events that have really helped generate that momentum toward law reform. And those include the horrific massacre that happened in 2020 at Portapique, Nova Scotia, as well as in 2021, the Federal Justice Committee produced a report looking at gender-based violence, in particular, coercive and controlling behavior and intimate partner violence, as they were examining, I guess, the response to shelters and frontline workers who recognized that there had been an uptick in reported in the sense of frontline workers experience of domestic abuse, and frontline workers were supporting survivors and victims of domestic violence during the lockdown. So this question of kind of thinking about criminalizing coercive control and how that whole process makes me think, how does a bill become a law? And I want to maybe ask Pamela if you'd be willing to start us off today with that, answer that question. How does a bill become a law?
I'm happy to do that, Angela, but I feel like I have to say one other thing before I do that. And it's that certainly the events in Nova Scotia in 2020 contributed significantly to a national dialogue about intimate partner violence, a national understanding that it is a serious problem. But the pandemic really, I think, was the first step in that direction when we saw the rates go literally through the ceiling. Media coverage was, in my opinion, the best it's ever been. And if there is such a thing, average Canadians suddenly realize that this isn't something that, it just happens over there. It happens to the odd woman or in the odd family. So I feel like we've been building towards this moment for several years. That being said, there was a previous private member's bill before Laurel Collins's bill that was introduced by another New Democrat,
right.
Randall Garrison, in 2019. So the concept of criminalizing coercive control has been around for quite a while. Okay, so now to the technical part that you'd like me to start us off with here. A bill is basically a piece of legislation, an idea that is introduced by either a federal or provincial representative, elected representative. In this case, because the criminal law is a federal law, it was a bill introduced at the federal level by an MP. More commonly, bills are introduced by members of the government, and those become government bills, and they pass more easily. They go through the same process, but they pass more easily because they've got the full weight of the government in power behind them. They've got the resources of that government, and where there's a majority government, unless a member of that government votes against its own party's bill, the bill is going to pass. It's really uncommon for a bill like this one, introduced by a private member, meaning somebody who's not part of the governing party, in this case the NDP, it's very uncommon for that kind of bill to pass. And so that's an interesting phenomenon on its own, and maybe we can get into why that happened a little bit later. But the process itself is fairly straightforward. The person who wants to make the change or make a new law or whatever it might be writes a bill with the help of their staff, hopefully also after consulting with stakeholders in various communities who might have something to add. They introduce it to the House of Commons. It has what's called first reading. That's a fairly mechanical process, in my opinion. Most bills make it through first reading. It then goes to second reading, where there is substantive debate and discussion by MPs from all of the parties. Whoever wants to talk about it can talk about it. And if there seems to be some interest in moving ahead with the bill, there will be a vote. The bill will then almost always be sent to committee. There's many standing committees. I'm not going to list them off. This one went to the Standing Committee on Justice and Human Rights. That committee is made up of MPs from all parties that are represented in the House of Commons. They have their own discussions. They have their staff do research. They may, and they did in this case, hold hearings where they invite experts to appear as witnesses to speak to the bill. Here's where this bill was quite different from most other bills as well. After those hearings, the bill underwent a total rewrite. So Bill C-332, as it was passed in June by the House of Commons, looks almost entirely different from the bill that was debated at second reading and the bill that many of us made submissions about to the Standing Committee. So that's the first part of the process. First reading, second reading, third reading. Then it passes to the Senate, where the Senate replicates that process. First reading, second reading, third reading. At second reading, it can go to committee. Just like with the House of Commons, that committee can hold hearings, they can do their own research. One final comment about the process is that since the Senate was significantly changed when Justin Trudeau was elected Prime Minister for the first time, the Senate used to be kind of a rubber stamp, but it is now a very actively engaged group of people, often who push legislation in a more progressive way than the House of Commons did. So it's not the old dusty conservative, put up your hand, sure, that's fine group that it used to be. Issues, including bills, get really thoroughly debated at the Senate. And sometimes the Senate comes back to the House of Commons and says, you didn't go far enough, we want you to do this. So it goes through those three readings. The Senate reports back to the House of Commons. If everybody's in accord, then the bill becomes legislation. Or the Senate can report back to the House of Commons and say, we'll approve it, but you need to make these changes. The House of Commons debates that, and the changes either get made or they don't get made. So any kind of constitutional expert would say that I really gave a glib overview of how this happens. But I think in terms of just understanding the basics of how you go from somebody has an idea through to a new law, I think I've hit most of the main points.
Super helpful, thank you. And we're at the Senate area right now, aren't we? We're there at
yes, it's at second reading.
Second reading at the Senate. Okay, very interesting. Yeah, and I know that both, well, all of you, I think, with the exception maybe of Summer, and Agnes Wong is here. Hey, Agnes, good morning. Good to see you. Good to see you. We just started, and Pamela was kind enough to give us a bit of an overview of how a bill becomes a law. So, and I know that Emily and Deepa, their organizations did do a submission. Deepa, would you care to share kind of what mattered to you at that time, and like what was important for you and your colleagues in preparing your submission to the House of Commons and contemplating the criminalizing of coercive control?
Absolutely. First of all, thank you so much for organizing this conversation. And in terms of the submissions that we did to the Standing Committee on this bill, and then there was a study that has also been conducted on coercive behavior. which we were also invited to. So we have done submissions on coercive control and coercive controlling behavior twice. Although in both the submissions, the clinic's submissions were very much rooted in the experience of marginalized communities and the fact that marginalized communities and racialized communities and people with intersectional experiences are already under a lot of oppression around criminalization of the existing framework of which tackles gender-based violence. The mandatory charging policies and how they play out in people's lives is something that we are well aware of. And we see that very routinely the same laws and same frameworks that are supposed to protect survivors, they find themselves being wrongfully charged or wrongfully criminalized in the process. And a lot of our submissions were rooted in that experience at the clinic. We did acknowledge that coercive control is one of those most complicated experiences of gender-based violence that needs to be well understood and well recognized, and there needs to be a way to unpack it in our judicial system. But that judicial system is not where we are in terms of our experiences currently. So our recommendation was that there needs to be first of all, looking at what do we mean by coercive control and unpack the coercive control as a definition as it applies, because it is the challenge is that you would you will create a new law which will never be able to be applicable and never be able to benefit the survivors. And then two, to look at the current scenarios of how these situations are playing out in the system so that you can actually address the issue at its core and just not create another, either a band-aid solution or a solution that actually may land up harming and get weaponized against the survivors themselves. So that is where our submissions were designed around and drafted around. A lot of challenges that we see is that the impetus for these changes is coming from what is happening globally, or incidents that you just mentioned that happen locally, and everyone wants to do something about it, and rightly so. We are not at all at any point saying that the coercive control should not be addressed. But the question is this the law that we need? And is this the solution that we actually need for the survivors to actually get the protection that they need from a legal framework? So I'll wrap it here, and then hopefully we'll get more chances.
Yeah, no, thank you so much for that. That's and I was thinking about like how that even is defined, how we define coercive control, and I understand that Evan Stark, I guess he had was a psychologist, I believe, or a psychiatrist maybe, who one of his books was Coercive Control, The Entrapment of Women in Personal Life. And he wrote that book, I understand, I think in 2007. And that was, I guess, the time when coercive control got on the map in that way. But of course, we can go back to the 1980s and Duluth, Minnesota, and the Domestic Abuse Intervention Program, where they created the Power and Control Wheel through speaking with women in the transition house, and that wheel has 8 tactics of power and control and then kind of surrounding the wheel is physical and sexual violence. And I think the intention of that wheel was to highlight the ways in which an individual can be in an extraordinarily abusive relationship and nobody's been hit. And that, of course, for the most part, the criminal legal system is focusing on, physical assault and sexualized violence. And then what happens within the circle is a bit more complicated and more likely what's happening within an abusive context. And so coercive control has really taken hold. And how do we make sense of kind of how this is, the last, I guess, 10 years, going back to the UK, how is it this idea of coercive control is being centered in so many ways now in our understanding of violence? Emily, have you had thoughts about that as you've been analyzing it through your work?
I I think, let me just start by saying that I'm sitting right now on the land of Ganyangahaga, which I'm normally in Algonquin territory, but I just wanted to acknowledge that I'm now just outside of Hudson, Quebec. So thank you very much, Summer, for starting us off in a good way. And I also wanted to mention, if anybody's interested in like a cartoon adaptation of how a bill becomes a law, there's one called The Schoolhouse Rock that was developed a long time ago, which is about the US system, but it mirrors our system, so it's really similar. And so for those of you who don't know, the Canadian Association of Elizabeth Fry Societies is a national intersectional feminist organization. We engage with legislation like the proposed legislation that we're discussing today. However, there are also 22 local Elizabeth Fry societies across the country who do their work in community, supporting people who have been criminalized and or are in danger of becoming criminalized. And many of the local Elizabeth Fry societies work with people who have experienced extreme violence in their lives. And so human beings our brains like to, make things very neat and tidy, right? We like this idea of perpetrator and victim, but we all know that people's lives are much more complex than the ways that we put into boxes. And it's really starkly illustrated in the work that we do at the local Elizabeth Fry societies, which informs the work that we do nationally around things like intimate partner violence and aspects like coercive control, because so many of the women who have been criminalized and end up in our jails and our prisons have experienced extreme violence in their lives, including coercive control, and elements like, control over their not only their finances but their bodies, etc. So I just wanted to make that really clear, because often criminalized people who have responded to violence in their lives, perhaps with violence themselves, or perhaps have been criminalized for surviving, they're not often brought into these conversations. And so I really want to thank you, Angela, for bringing the Canadian Association of Elizabeth Fry Societies into this discussion, because we have to be able to have nuanced conversations about this. So back to your question, why is this coming up now, I think was your question. Certainly, you talked a lot about the Mass Casualty Commission, but if I look at the work of Pam Cross over the many years that she's been working, she also participated in the Renfrew inquiry, which had a lot of recommendations coming out around intimate partner violence as well. And I think this is wonderful, actually. We need to be talking about coercive control. There's no denying that. This is a pervasive issue that forms a pattern of control across intimate partner violence for so many people. And so much of the recommendations that, Pam and Deepa and organizations like CAPES have made is around these kinds of opportunities to have conversations about coercive control, because the more people understand it, the better we're able to make interventions around preventing it in the first place or responding to it. And so I think, yes, it has been coming to light over the last 10 years in other Western nations as well, which has led to these conversations happening in Canada and the legislation that was proposed first by Randall and now by Laurel. So that's my impression. I'm sure that my colleagues have other thoughts as well.
Mm-hmm. Thank you for that. I appreciate that, and the work of your organization and all of those member organizations across the country. Summer, I think here in the West, coercive control hasn't really been perhaps as prominent as a term perhaps than that we're seeing in other regions. And why do you think why it's become so relevant at this moment in time?
Is it back to me?
Oh, no, Summer, sorry,
Oh,
Summer.
Summer. Oh, I didn't hear who you were asking. Okay, great.
You're welcome to answer. I think I think the idea of coercive control, being able to control one's reactions, thoughts, process through intimidation has always existed. It's not that it's a new concept to abusers, but I think it is a new concept to the justice system. I don't really like calling it justice system because it's not very justice, but to the system in a lot of ways. In the fact that, you know, repetitive actions, behaviors, language, can it control somebody long term? Can it create or instill fear? Is it an ongoing risk or a threat? I think in the systems here, they're always looking for concrete actions, evidence, and ultimately they're looking at the urgency or the need, and does coercive control meet that level of urgency or need in order for the system here to respond, whether that is family law, whether that is criminal law. I think we started seeing coercive control come into play almost a decade ago in regards to abusers turning their tactics to using the state as an ally in having women arrested or detained or charged or hospitalized under the Mental Health Act by bringing in elements of that control and twisting the actions or provoking a response like that normally would not be there. So I don't think it's new. I think we're just being forced to look at it a little bit differently and to extend the concepts of what psychological, emotional, financial abuse looks like and putting that into a context. Although, do I think the system has a way of measuring that? I don't believe that the system has a way of measuring that and determining the risk factor or the frequency factor for survivors.
Yeah, no, thank you for that. And that makes me think about what we see in family law here in BC and maybe in the Divorce Act, kind of federally. Agnes, what are your thoughts as you look at this idea of, you know, criminalizing coercive control, but then also what's happening in family law and maybe with the Divorce Act and that language? Is there any relationship that we can draw?
Yeah, so first of all, thank you very much. I'm sorry I was delayed in coming. I was being forcibly controlled by Zoom. But I also want to acknowledge I am here on the unceded and traditional territories of the Squamish, Musqueam, and Tsleil-Waututh Nation. With gratitude, I get to work, play, and exist on their beautiful territories. And again, thank you, Summer. I did hear your, thank you very much. And I have had the honor of working with Angela and Summer Rain for a long time. So, and I know of the rest of you, and I'm really glad to meet you, the panelists. You know, family law, the term coercive control in the family law cases in British Columbia is really rare still. I'm very jealous of you folks in Ontario. This is a reason why perhaps we should have unified family courts with judges who are actually trained in family law. Because I was able to read some cases, and many of them come out of Ontario that has some, at least, acknowledgement and some real discussion of what coercive control is. And unlike in BC, it's a bit sad still. In 2013, we got the new Family Law Act, and that's sort of when family violence sort of was supposed to come to the forefront in family law cases, but it still hasn't. And in terms of criminalizing coercive control, I take the same position as my colleagues here on this call about the dangers of that, because in family law, we've certainly seen how family violence terms get used against women. The courts talk a lot about high conflict. It's not family violence. The court uses alienation versus family violence. The court can't really separate. Well, they try to separate sort of, well, is this coercive control or is it just really bad behavior? Somebody's being a bit of an asshole, so it's okay, you know. It's also very situational. It's time limited, and so courts here aren't very good yet at really understanding the impact of coercive control. And I think one of the dangers of just using the word is that word just has no meaning. And it's really not the term coercive control that's important. It's really looking deep down to what kinds of behaviors are happening, what kind of conduct is happening, and what is the impact then on the person who is this, you know, at the brunt end of that coercive control. And so I look towards, I started writing this whole list of what behaviors could be coercively controlling. And a lot of it, you also say, well, it's not necessarily, I mean, do we actually need a pattern? because oftentimes you're not going to actually see a quote pattern as in this particular act is going to continue on and going. It's just you're going to see a whole bunch of different acts, a whole bunch of different things. And a particular act on their own, sending a few, nasty emails, calling somebody psychotic, is that enough to be coercively controlling? No. You look at the whole, that is ongoing. And then you look at the impact on the woman who's experiencing this. And I always find it's really important because, courts are very much about being objective, right? Being the reasonable man standing outside. And when you do that, most of what you read in the court cases about actions, you'd be like, yeah, well, he's a bit of a jerk. So what, and it's not considered control. Whereas I'm not sitting in that place of that woman who's experiencing this. So, I have a client who's he calls her psychotic throughout. And to me, it's like, oh, what an asshole, but I don't know the impact I do know the impact on her. And we have to stand in that place. Whereas a court, might minimize and say, oh, so he called her crazy. He thinks that, she's a danger to the child. Well, that's legitimate for him to say. Well, it's not. So anyway, I'm sort of rambling a bit about, there's just a lot we have to unpack to make sure that we can really get the courts to understand how these types of behaviors impact on women and how then it should affect perhaps the parenting regimes. And the courts don't. I mean, the guy can be the worst of the worst. We know this. Men who've been convicted of murder, whatever, they can still see their kids. It's still about the best interest of the kids. It doesn't preclude that. And so we're very far away from really having a good understanding and sensibility of how coercive control plays out in parenting issues, particularly, or in family law in general, because it can come into property issues, it can come into spousal support, and it can come into child support. So perhaps I'll stop there.
Yeah, no, that's very insightful. Thank you. And like that analysis. And I guess that's what we've been discussing, I think, in some of our conversations leading up to this. I know, Pamela, the part around evidence and how to, the evidence, like, the way in which the incident-centered way that the criminal legal system works currently, and I guess in so many ways the family law system as well, that it's based on one incident and that we're not able to kind of piece together within the evidence collection part of it in terms of making any kind of case. You care to comment on that, like looking at that incident base and the evidencing, and I'd like to maybe ask everybody to comment on that after Pamela, please.
I think it's a great question to open up the issue of the differences between family and criminal law, and why something that could work in family law might just not be possible to work effectively in criminal law. So what do I mean by that? And I do want to say right at the outset that without proper judicial education, and Agnes, I'm not quite as optimistic about Ontario judges as you are, and education for lawyers, it doesn't matter how great the law is, because the people who are applying it, the people who are interpreting it, have to understand what it is they're interpreting and what the ultimate goal of the law is. But if we can just set that aside for a minute and think about the law as it's written, I think there's a really big place for coercive control in family law, because family law is not about determining whether somebody's guilty of something. It's about what are the best arrangements for the children. And as all of us know, and a number of you have already said, coercive control is a sort of all-encompassing reality for the victim, the primary victim, but also for any children who are in the household while that kind of behavior is going on. It absolutely, in my opinion, has to be part of a definition of family violence. And as the Divorce Act in BC and Ontario and some other provinces, provincial legislation says, you got to consider family violence when you're making any decision related to the children. Family law can, in fact, and must and does look not at single incidents, but at the whole story. What went on over the 10 years of this relationship, or the 5 years of it, whatever it was. This is where we get into trouble, where we just try to sort of move a concept from family court into criminal law. Because, as you said, Angela, criminal law is single incident focused. Did this individual person on this specific date do this particular thing? And that's not what family violence, intimate partner violence is, especially not coercive control, because it's happening every day in one way or another. So, you can find evidence to meet the family law standard of proof on a balance of probabilities if you've got the right players, if you've got the right judge, if you've got the right lawyers. It's not impossible to tell a story about coercive control that will lead to a safe outcome for the family. In criminal court, how do we even start? Police officers, with all due respect, are not even that good at laying charges appropriately when there's been an incident of physical assault. And we see how abusers manipulate that moment where the police become involved. We see where all of the intersectionalities that Deepa was talking about a few minutes ago come into play on behalf of both the primary victim and the person who's causing the harm. If they can't get it right to figure out that he punched her in the face, how is a woman going to explain, well, over the last 10 years, he's made me feel like a worthless piece of shit because he's taken over all the decision making. He doesn't let me see my family, and so on. Plus, the standard of proof in criminal court is different. It's beyond a reasonable doubt, as it should be. We don't want people going to jail because somebody thinks maybe they did it. But the whole concept of coercive control, you can't just transplant it from a family court system that's not about guilt, but about finding a way to move forward and that looks at the whole history of the family, into the criminal court where we're looking at what happened on this day and is this person guilty of having committed a crime.
Thank you. Yeah. What do you think, Emily or Deepa, Summer? Any reactions?
I can just quickly say, I think one of the places that, you know, Deepa's work and our work and Luke's place work and anybody who works with people who are criminalized around intimate partner violence, we all understand that there are certain communities in Canada who are already overly surveilled, that law enforcement is already part of their daily realities. And so, you know, adding another layer of criminalization to what is happening in their daily lives is pretty dangerous for them. And so, you know, I worry about, as Pam has said already, how bias, which is already existing in our current system, will rear its ugly head in terms of how it plays out when people are trying to assert coercive control or disprove coercive control. And, you know, I always say this at every presentation that we make. 50%, half of the people who are in our prisons designated for women in Canada are Indigenous. And so we have a really big problem right now. It's a mass incarceration issue of Indigenous people in this country. And adding another criminal law that could potentially harm them, which has the intent of supporting, because also, you know, at the same time, Indigenous women are have a higher likelihood of experiencing intimate partner violence. So we are at the same time underprotecting, but then overly incarcerating and punishing Indigenous women and gender diverse people in this country. And so we have this really big problem that will continue to be exacerbated under a law that is hard to prove. So I'll just put that out there and turn it over to my fellow panelists.
Yeah, who's next? Thank you for that, Emily.
So I just wanted to add that one of the challenge with the law reform in this area is that the understanding of the gender nature of the violence is somehow not being recognized. And this is when we know that the data is very clear and our experience on the ground is very clear that that approximately 90% of the survivors who report are all women identifying folks or gender diverse people, right? So we also know that women and survivors who come forward and report themselves, they are not able to speak to the the whole context of the coercive controlled behavior themselves. And in case of the police reported, where the police is intervening and showing up, their own understanding of what is a characterization of this coercive control behavior between these two parties is not at all captured in the reports ever. We see time and again. So one is that there is law being made, and one is that is the problem in existence. Yes, the problem does exist. The pattern of violence is not necessarily incident based, but our services, the frontline police reported services, or any kind of enforcement that happens, including child protection services or mental health services, none of them are trained to understand what pattern of violence and coercive control is. So for me, one of the problem is that folks are not trained to understand it. I agree with Pam that our judiciary is not necessarily trained to understand it and capture it, but also the underlying challenge that this issue is a very gendered issue, and it impacts women and gender diverse people a lot more. But this understanding, or this reform in the law that is being brought forward, is not actually looking at those gendered and controlling relationship concepts in that light. And therefore, the fear is that A, it is not understood, and B, it will be then applied uniformly as the mandatory charging has been applied. And what we will end up seeing is that more women are being harmed by this new law, because they would definitely be, the language of criminalization, you can call it, or legal bullying, you can call it, because all of that shows up in these experiences. And then we will see that there are lots more cases of coercive control now coming forward against women themselves, or who are the ones who need support and who need. But I think another factor, which Pam just alluded as well in the context of the family law, is that survivors of violence don't necessarily survive coercive control in some kind of a vacuum. There is a role of colonialism, racism, heterosexism, transphobia, ableism, and other structures of oppression that also play a role and shape their experience of violence and affect the coercive control. And I feel like the way the law is structured, it will land up creating an environment of erasing those experiences. And some of the language that I'm seeing in the bill is really highly problematic, right? Like alluding to talking about controlling of people's religion, controlling of culture. I see a lot of that, which basically is taking the experiences out of the real context of intersection of oppressions and taking into this their own light version of understanding what control means in these relationships.
Yeah, no, thanks for that. And I was, reflecting with both your comments, Emily and Deepa. And just before I get to you, Summer, I think we have to can't, escape the reality that the legal system is embedded in the law of the land, which is patriarchy and colonialism. I mean, those are the laws. It's the law of the land. And so much of what we're looking at in terms of the individual experiences of abuse is about this micro or individual experiences, but it's in the context of this other macro coercive controlling reality that is, that really grinds down in the lives of so many, and especially Indigenous women and girls. Care to comment on that with respect to what you're seeing on the front line right now? Summer?
I think so. I kind of wanted to answer the other one first. So
well, go ahead. You go where you want to go. You say what you want to say.
Okay, great. So I mean, Emily, Pamela, and Deepa covered many elements of of what I would say, but I do think that in BC, you know, we have a few things that are dictating how we are working. So we do, in regards to the criminal justice system, we do already have the so-called violence against women in intimate relationship policy, which is supposed to be guiding the police in how they are responding to call or DV calls. I prefer intimate partner violence calls, but DV calls in which they're supposed to be looking at primary aggressor. They're supposed to be looking at lethality risk, history, which we already see the front line, which is the police, failing in multiple areas to follow this policy, which is, in my opinion, set out rather clear as to what the steps are into specialized training and how to respond to DV cases. When you add a layer of coercive control and the fluidity of each constable to determine what that is, when most of them are enacting it in their daily lives, I don't see how that is going to work. And in fact, I agree with Emily and Deepa that it's actually going to be reversed. And I think more survivors are going to be criminalized for acts of coercive control or so-called coercive control or accusations of so-called coercive control, because as the person who's perpetrating the violence, it gives another outlet to try to use the system to penalize the survivor or to punish the survivor or intimidate the survivor by being able to implement this mystical concept of coercive control. Not that it's actually mystical, it's a legitimate thing, but I mean, in law it is. I don't understand how it's going to work or be enforceable in any kind of way, as so many things are already left up to individual interpretation and therefore almost never favor the survivor and in fact penalize the survivor. In regards to family law, I suppose there may be place for coercive control in family law or a CFCSA in an element, but I think it can't be separated from the best interest of the child, such as other forms of family violence already are in the Family Act, in the fact that it's often broken down to like individual acts of violence may have happened between the parties, but that doesn't affect parenting time, or individual acts of violence may have happened in the past, but they're not present. So therefore there is no risk or urgency or need of protection. So trying to situate coercive control, which does exist kind of in other elements in the family law, impacting protection orders or impacting parenting time or in particular decision making, because that's where you see a lot of coercive control come into play. I don't see how that's going to necessarily fit within the FLA as it is laid out currently, because it maximizes access to both parents as being the best interest of the child. So I think coercive control or family violence has to be more connected to best interests of the child, and also how that coercive control often falls onto the child in order for it to be considered a factor. And yes, obviously, I think that Indigenous women and women of color and immigrant women are impacted by these elements way more. They're targeted way more. There's already additional barriers where like, in particular for Indigenous women and girls, the act of coerce and control is ingrained to most of us from the state as it is itself. So flipping that over to an individual person and separating that out from the element that the state controls, I don't know. I struggle with it, but I think it is going to definitely impact negatively more. And we're going to see more women of color, more Indigenous women criminalized and or retaliated against in family court for acts of so-called coercive control.
Thank you for that. And
well, Angela, can I just say something back to
Yeah.
Summer really quickly? Because I really appreciate what you just said about state involvement. And one element that we forget about in this conversation, that I forget about mentioning, I should say, is when someone already has a criminal record or is on parole, so is already criminalized, it's actually even easier to control them, because then you can call their parole officer or you can call the state and you can say, even on suspicion, this person has done this thing, and immediately they're brought in, and this happens all the time. And so if a person who has a criminal record or who is on parole is experiencing coercive control, they're likely not going to report it because they don't want more state involvement in their lives, and they don't think that they're going to be believed, or their children will be taken from them if they have care and responsibility for their child. So I think that's another element that we need to be really, and thank you for bringing that up, Summer, because it just tweaks something in my brain.
Yeah, amazing. I want to share the results of the poll with everyone. And can you all see that? We asked the question, should coercive control be criminalized? And the majority of our attendees today do think it should be, with a smaller proportion saying no, and then about a third saying not sure. I guess it leads me to kind of think about this, the role of the law and the legal system and police, and the way that it's been positioned in a sense as legitimizing the experiences of individuals. Because we know the vast majority of cases of intimate partner violence are not reported to the police, and reporting, of course, is the term that we use, and and legitimizes the experience. And for instance, if I tell my if my neighbor lets me know that she's experiencing abuse, she's reporting to me in a sense, but it it doesn't get registered in an official way. How did the law and the state become the validator for these experiences of that so many are dealing with in their homes all across the country? Anybody care to answer that?
I'd be happy to jump in initially. And in doing so, I just want to add something to what Summer said as well. And that is, I really agree with what you said about, and I'm paraphrasing what you said, about the need to tie coercive control sort of undeniably with the best interest of the child test. But we have to do it in a way that doesn't let us forget women without children who are being victimized by coercive control. So we can't frame it all as what's in the best interest of the children. There's lots of women who don't have kids, or whose kids have left home, or for other reasons aren't living with them. And we want to make sure that how we understand coercive control also is understood to apply to them. But to go back to what you were just saying, Angela, I think this is so interesting to me, and I think it's in some ways really complicated. There was a time in British common law, which is the system on which our legal system is based, where crimes against women weren't in fact crimes against women. They were crimes against the men in their lives, their fathers, their brothers, their uncles, their sons. So that wasn't so good, for sure. We also moved in what I think is generally a good direction, that we didn't want a sort of vigilante system of law, that in fact, if I harm, say you, Angela, it's also a harm to the whole of society. And we want a system that has some consistency to it in terms of how we look at that. When I started practicing law, which was about 30 years ago, and women, my clients, would tell me stories about, we didn't call it coercive control then, but that's what they were telling me about. They were so frustrated that there wasn't a law against it. And I understood that frustration. I shared their frustration, because for them, they had grown up in a country that said the law is how, the criminal law is how we determine what's bad and what's good, what's right and what's wrong. And I think, we can see that whole philosophy, if that's even what it is, attitude, taken many steps farther if we look south of the border into the United States. But certainly for folks who grew up in Canada, that's what we grew up thinking. The policeman, and I'm using these words on purpose, was there to help us when something bad happened, or when we were scared, or when something went wrong. And they would help us by finding the bad guy and putting them in jail. Right. And I talked to and listened to so many women who said, so if he just shoved me hard, the police would come, but they won't come because, and then they would describe basically serious emotional abuse. The majority of women I worked with said they would prefer to be physically harmed over emotionally harmed because it would be easier to explain it, not just to the police, but to their family members, their friends, and their colleagues. So that's the system in which women who come to our various organizations or our law practices or whatever, that's the context in which they're coming to us. They think that there has to be this kind of law that says this is wrong, and if you do it, you're going to get punished for it, and somehow that's going to heal me, the person who was victimized. And you don't have to do a lot of thinking about it. I'm sure we're all on the same page here, but because 60% of the folks at the beginning of this webinar were in favor of criminalizing coercive control, I just want to say I challenge everybody to think about it differently, because we know that women aren't satisfied with the criminal process. They talk about not being heard. They talk about feeling re-victimized, and those stories get worse and worse for women the more they're marginalized from being a woman who looks like me, you know, white and older and middle class and born and raised in this country and so on. So I think that Lee Goodmark put it best a number of years ago when I heard her speaking, and she's really done so much good thinking about this stuff. She talked about how, say, before the bad thing happens, you've got two people who are sort of on an equal playing field. And then in the case of IPV, the harm happens, and this is the person who's being victimized, goes down. They've lost that equality or relative balance. And the system says we have to equalize them. And what the criminal system does is equalize them by damaging this person further. So now they're equalized again, but below where they should be. What if instead we said, how do we bring her back up? And part of bringing her back up is to use a process that isn't just about guilty or not guilty, where the accused person does everything they can to try to make it look like they're not guilty, because that's a bad thing. Encourage accountability, ownership, taking responsibility. Understand that often the people who are causing harm have themselves been harmed and need an opportunity to heal, to be responsible for what they did, for sure. But otherwise, we're just going to keep doing this forever and ever and ever. Criminal law doesn't fix, it just punishes. And it's often wrong. It often punishes the wrong person.
Appreciate
Can I jump in and go from what Pam was talking about? I appreciate your comments, and talk about how when different particular acts are criminalized or are supposedly sanctioned by the state, how that can have an impact in the family law context. And this is the same. We all know, I mean, we know that there's a different standard of proof in criminal law than family law. But in the end, it doesn't matter, because if a man is not convicted of a physical assault on his wife or a sexual abuse of his children, if he's acquitted or if it's stayed or whatever, you know it's playing into the minds of the judge in the family law context. They're like, well, it didn't happen, because certainly that's what the man is saying, the father, the husband, whatever. That's what he's saying. And so you get another layer here if you add in coercive control, is that if, of course, first of all, if the mother doesn't report, the woman doesn't report coercive control to the state police, to the police, that must mean it didn't happen, or it's not real, or it's not really that, you know, important in her life, or not much of an impact. And that will play out in how things happen in the family law context. And the same happens with the ministry. The ministry has the Ministry of Children and Family Development, you know, the child protection forces here in British Columbia have no way to deal with coercive control. I mean, they can barely deal with emotional abuse, psychological abuse at all. I mean, it doesn't fall into a protection concern. So again, it gets used against women who are saying, this is happening, this is real, to say, well, the state doesn't actually agree with you. The other parts of the state don't agree with you. So it's not real at our end. So it ramps up then the onus on women to prove that coercive control is happening, and then what the impact is. Particularly when it comes to the children, right? And if it's happening to the woman, I mean, how do you play it out? It's like, I've read something where it's like, well, you know, he did all this stuff, but the children weren't there. So it obviously has no impact on the children. I mean, other judges have one said, you know, look, you know, children need to have an emotionally strong and supported mother in order for them to overcome whatever they went through. But even if they didn't experience anything, they deserve to have a mother who hasn't gone through this. And I wanted to talk a bit about evidence and in proving these cases, and drawing from what Deepa was also saying about, I mean, we do live in a colonial society. There's histories of racism, like realities of racism, homophobia, obviously misogyny and so forth. And credibility is everything in the eyes of the court. And a lot of times, and I think all of my other panels would agree, that most of the time our clients, women, don't actually realize what has been going on for them, that it could be violence, it is coercive, or even recognizing that things happen. You know, that if the husband or says, oh, well, no, oh, don't go see your friends, like, or don't call your parents every week or something, that is a sign of coercive control. I mean, lots of women are in such trauma that they can't recognize, let alone mount the case with evidence, with corroborating evidence. It's certainly, they're not sitting there. One of them is like, the corroborating evidence would be like, you have contemporaneous emails that acknowledge, that talk about, the abuse that's going on. Well, most of the time women are trying to just survive these situations, or they're trying to just raise their children or work or do whatever. And how then would they be thinking strategically, well, okay, I should be videotaping this, or I should be writing these emails and, saying this is what you did to me. And who knows if those are true anyway. A lot of men do that anyway, just to, create a record. We know that. And then there's, things like, I was reading one case where the judge basically said, well, the woman was accomplished in her life. She was educated, had a good job. So therefore, like, there couldn't be coercive control, because if the husband was coercively controlling, she wouldn't have succeeded. So there's lots of bias in terms of how we perceive and judge women and how they respond and react. And there is no one way that a woman is going to react to being subjected to coercive control. And also, we as a society and courts are not very good at sort of, we think that a relationship ends and the coercive control or that kind of behavior ends, and it doesn't necessarily. Sometimes it takes a different form because the abuser doesn't have direct access in the same way as they did during the relationship. And, courts are very not good about really looking at future, right? They sort of look at, they sort of talk about, what's the risk, but they don't look at the impact. Because a lot of times, of course, the fear of mothers is that if he is doing this to me, he's going to do this to our children. He may not be doing it now, but he will. And the courts can't handle that. They have no way to process that unless, there's actually that kind of coercive conduct happening towards the children now. They can't handle that. Maybe if, he is treating the mother this way, he's going to do that to the children later on. Or maybe he is doing it and we don't know. Anyway, I think, it's very courageous for women who come forward with coercive control, but I've seen so many who are just totally slammed by the court, slammed. And it has a huge impact. There's this whole notion that a lot of times that violence is mutual. And so if a woman reacts to an act of coercive control by yelling back or throwing something, or or withholding the children, that's a huge one that courts like to see as, they see that as coercive control, and that's the danger of it in a family law context. And so I do fear, when there are things like, if things are not proven in a criminal law context or in the ministry context or whatever other state, context, that it does flow down negatively for women in a family law context.
Angela, I think you said, since when did the police or the justice system start? Is where I think where you're going, and I think for me, it took me a minute to figure out your question, because I think as an Indigenous woman, the police and the child welfare system have existed from day one to police the movements and thought process and dress and wear and culture and religion of Indigenous peoples. So we have been criminalized for being Indigenous from day one. We've had our children taken for being Indigenous, for participating in our ceremonies and our culture and speaking our languages. I think we're not seen or heard in the justice system. The justice system or the legal system is not built in any way to support Indigenous people, let alone Indigenous women and Indigenous children. So I don't see how that is going to, like, I see that actually hindering in the criminalization of coercive control and also in the family court, because Indigenous women are still being punished for being Indigenous women. And so I don't know how you can criminalize something that the state itself is doing by an individual person. So I'm struggling with your question as to, like, since when were they able to do this? And I think for me, I don't know that there's been, or for any Indigenous woman that I know, I don't know that there's been a minute of any day that they've been able to exist in this world without the element of coercive control existing in their lives, whether that's education, child welfare, family law, criminalization, employment. It exists in every minute of every day. So to then transfer that to criminalization and or continue to be punished, I don't see that it's going to work. So I'm struggling with your question, but also just the mere existence of it.
Yeah, no, thanks, Summer, for sure. Yeah, no, I know everything 100% what you're saying. I probably phrased the question awkwardly. I was thinking from the point of view of when did the criminal system become the measure of validating the experience of gender-based violence, interpartner violence? Because I think there's something in that, in the sense of coercive control, we know is endemic in so many ways, in a micro way, in abusive relationships, and then the macro way in the sense of the state and the different elements of the state, and that changes depending on the social location of individuals and groups of people. So what I was thinking was then when the MP here in Victoria, just across the way here in Victoria, made her statement, there was so much support that we saw online, and not unlike what we're seeing today with the poll, like a real sense, like this is good news. Like this is good news. Now, the state has recognized coercive control. It will be criminalized, hopefully, as is understood, and that this is a good thing for victims and survivors. Because it's now creating an opportunity for victims and survivors to have their experiences validated by the state, to have their abusive partner held accountable for those behaviors. And I do believe that there is an element of a desire to punish abusive people, in part because of the punishing experience it is to live within an abusive relationship. So I got that kind of question from the perspective of, how did we as a culture, and I mean we, whatever that means, the global we, I guess, become kind of in this position of wanting the state to validate this experience, and is that what do we do with that, knowing, I mean, Pamela talked about it certainly, but there's something in that, in what's happening on individual victims and survivors' lives, and everybody that seeks to have coercive control criminalized, not only here but in other parts of the world.
Angela, can I try to address it from my understanding, and then I'll hopefully. And I also wanted to say something about what Agnes said about the credibility, which is I think is at the core of the problem for a lot of survivors engaging with the formal legal system. So in terms of global context and Canadian context, and having the privilege of coming from another part of the world and making Canada my home, I see there is a common element of a few things. The common element is that globally, survivors, when they come forward to speak about their experience, they are coming forward and engaging with the system because they want this to stop. Every survivor I have worked with over, close to 28 years, I've been doing this work. It doesn't matter whether it was in India, England, or here, has always told me, I don't want him to be able to do this to another person. or I don't want this to be repeated. I'm speaking out because I don't want this to happen to anyone else. I don't want it to happen to my daughter, my granddaughter. And I think even most of us doing this work are wanting to end gender-based violence because we want this to stop, and we want it to stop right now. And that's why I want to speak up about it. The survivors, most of them also come forward with that as their goal. But within that goal also is accountability. And within that goal also is some kind of deterrence that can, the system can probably bring in against this person. They can make him accountable. And I'm saying him because, again, as I said before, it's a gendered issue. Most of the mothers are coming forward with the claim of coercive control, and it's not fathers. If you go by just looking at the review of the family law cases, Professor Janet Mosher, Shana Harris, and a few others have done that work. And in most of these cases, it's mothers coming forward and saying, and which involves both physical violence, but other patterns of coercive control behavior in those cases. Now, does that deterrence really happen? Does that stopping of violence really happen is the big question that we are all grappling with, because the current systems haven't worked. But current systems have also not worked because they're laced with that colonial mindset, and they're laced with that misogyny, they're laced with that patriarchy. How many times the judges in court question women's credibility when they come forward and talk about their experience of violence? How many times they are dismissive? And this is not something that we are just saying because we work in this area of law. Now, average Canadian is excited about a change in the criminal law and thinking there is new section on the criminal code, and there is new crime that is being created, and by having this new crime, we will have better protection. That's the right line of thinking, because you believe that there is a system that we live in which is regulated, and that is regulated by the enforcement and the court, right? If that's the mindset that you are coming from, you would say, yeah, great, we are doing something about to protect gender-based violence, survivors of gender-based violence. But they don't know that the judges in the courts say things like, here is an example from a case that Professor Mosher has quoted. It's a case called R versus RMD. It's a criminal law case from 2022. And in this particular case, the allegation of intimate partner sexual violence is brought forward. And the Justice Grezer held as follows in response to the Crown's argument that the assertion of the false claim, which is what the husband or the partner has claimed, is grounded in myth and stereotype. So the judge says, and I quote, "I can take judicial notice that it is not unheard of for a party involved in family law litigation to lie or exaggerate about violence having been committed against them to gain an advantage in parenting matters or property matters," end quote. We are not talking in abstract. I think the problem is that some of us who engage with these materials on a day in, day out basis, we are not talking about it in abstract. We're not talking about it as a theoretical framework which is not working. We're talking about what is happening in the courts not working. And so a common person celebrating a change, I'm not surprised that they are celebrating a change, because it is happening in the right direction in people's mind, because it is creating a law that can potentially prevent more violence from happening. But unfortunately, they are not engaging in the materials like Professor Mosher is, or Pam Cross is, or Agnes is, or Emily is, or Angela is, where we are seeing what is the practical implications of these laws and how these common myths and stereotypes are applied against the survivors day in, day out. And no amount, and this is where I think me and Pam Cross, I know that Pam Cross said in the beginning that there is judicial education, which is the key. And I'm like, no amount of judicial education right now is making the change. And I'm getting disheartened about it. Believe me, my heart is really breaking, basically, because as a lawyer, I believe in law. And that's why I became a lawyer, right? But when I see that, this judicial education and reforms that we have made, and they're supposed to bring the change, they are not bringing the change, at least not at the speed that we want. And hopefully things will change, and hopefully there will be better understanding. But currently, the stereotypes that Agnes was earlier talking about as like, the credibility findings is a big challenge. So I'm not surprised that people are convinced that this is a good step. But I feel like there is a dark side, there's an underbelly of our legal system that people are not exposed to. And if more people were exposed to that, then probably they would also actually question, is this the right way or right direction? And my biggest worry from working at the clinic, and believe me, at the clinic, we engage with the system in a way that we support survivors who want to report to the police and so on and so forth. We are not completely not engaging with the system. We engage with the system, we advocate for survivors, but we also serve 5 to 6 new clients every week who have been wrongfully charged by the system because their experience of coercive control has not been understood. So I hope that I'm being clear. I know I'm talking about a lot of concepts in one go, but I am personally not questioning why people are supporting it, because I understand that people on the surface of it believe that this is the right thing. And I also believe if it was actually doing the job that it's supposed to do, if more women were protected in our families, just legal system or our criminal justice system, I would also say yes. Having another charge on the books helps, but it doesn't, unfortunately, because all the other structural issues and systemic issues are not necessarily helping right now.
Can I just jump in quickly? Because I really want to build on what Deepa said there about a minute ago. When I was involved with the CKW inquest in Renfrew County in June of 2022, I sat in that inquest room for 3 weeks. There were 5 jurors picked randomly from a small, rural, largely white community. And they went through the process that you're talking about, Deepa, and we could see it every day. They came in there basically believing that the laws of this country worked and that the policies and programs and services that were available worked. So they sat there for whatever 3 weeks is, 15 days of listening to witness after witness, survivors, frontline workers, policy wonk folks, lawyers and others, talking about how these 3 women had been killed basically because nothing worked. And it was mind-blowing to see the kind of shield that they had that I think many Canadians have, just pulled right away. In an inquest, unlike in a trial, the jurors can ask questions, and they asked so many questions, and they pushed back when the answer obviously made no sense. At times they would swear, like sort of under their breath, but we could hear them in the room. They'd say, "For God damn it, how can that happen?" And by the end of it, here were 5 people who maybe never before had really thought about intimate partner violence at all, and certainly hadn't thought about this structure of criminal law that exists in this country, sort of little revolutionaries all of a sudden. And it was a really powerful thing to witness. And now where that's gone, I don't know. I've had some ongoing contact with members of the jury, and they've remained interested to see what happens to their recommendations. But boy, we do protect ourselves by pretending that these systems we've built actually work. And I guess it's a good thing in some ways. Most Canadians never have to confront the fact that those systems don't work. And those 5 people did, and they didn't accept it.
Yeah, no, we have that everyone. Thank you for that. We have that every once in a while when we get a chance to talk to lawmakers in the province and when they're looking at different issues. And recently in the last 3 or 4 years, I can't remember which year it was, there was a whole look at policing in British Columbia, and it was remarkable how that committee really had their eyes opened in the sense of what's going on the ground in terms of RCMP and municipal police in here. So I guess that's it, isn't it? That what Deepa was mentioning, that sort of underbelly of the law, and what we have on the top, which clearly Canada has some of the best laws on the books, probably in the world, when it comes to gender-based violence. And and yet, there's always these conversations about reform, and then I know that there's looking at what's happened in other regions with coercive control, and And I was surprised, I guess, or validated in some ways, looking at the UK with the organization, it's a national organization, Women's Aid UK, their advocacy and provide support services for victims and survivors there. And that it's been almost negligible in the sense of what the impact has been after the last 10 years of having coercive control in law, where there's been, I think in 2019 it looks like 9,000 cases were registered by police, which we're talking about millions of reports, right, of interpartner violence, and 9,000 actually resulted in charges. And then in terms of convictions, it's, almost nothing in that sense. So I think about 3 or 4% have ended up in charging in present day, that's what we're seeing right now, I think, with sexualized violence, which we know is ridiculous in so many ways. And that's just in terms of charges. That doesn't even talk about those that make their way into any kind of result be outside of the charge. So that's, and I've seen, and I've had some conversations with folks that are in the UK that have, that are really advocating, and right now their energy is in, in making the police do better, making the prosecutors do better, making the judiciary do better, and that their energy is now put into that, so that the coercive control as a crime now can be better used by victims and survivors for a measure of justice for themselves. And then I've seen stories in just kind of preparing for today where victims have shared their story and just got grilled by defense, have had their evidence just torn apart by defense, and that at the end, the ones that have gone public and that I was able to access, with my very quick look, they were glad they got a result, but the experience that they went through was the worst they ever had in their lives. And these were, egregious cases. Like it was coercive control on top of many, many things. So it's I guess that's that underbelly, because we're seeing, in light of what we're already struggling to do with GBV and the law right now, and especially when it interfaces with other areas of the law, such as immigration law, such as family law, and then of course child protection. Any reactions, comments?
I have like so many things to say, and I appreciate so much about what you just said, Angela, because I'm also a lawyer, and I believe very much. I thought I believed very much in the law when I studied law, and then you start to practice law and you go, whoa, it's not what we thought it was, right? And I recognize that as a white woman with a lot of privilege, that is where my perspective came from and what shaped my ideas around how the law should work and why it should work that way. Anyway, I did do criminal defense for a while, and you do see people who bring forward claims of violence or assault, and they are extremely traumatized by having to put forward that evidence on the stand. And so many people will not report it for fear of having to be re-traumatized again in telling it to the police, and telling it again to the police, and telling it to the prosecutor, and telling it again to the many people they have to tell over time, and then in open court, right? It's very, very damaging. And if you're a person whose credibility, because I think, Deepa, you wanted to talk about credibility, and maybe I'll just remind you about that, but whose credibility is already in question because you have a criminal record or because you are a person who's already surveilled, then you're going to be just really, really damaged by the process that will unfold. So the other thing that I wanted to mention is, and Pam talked about Dr. Lee Goodmark. So Dr. Goodmark wrote a book called Imperfect Victims, and the Promise of Abolition Feminism. And so our organization is an organization that believes in that prisons do not have the effect that we want them to have in our society, right? Like, we believe that prisons are going to provide public safety and rehabilitation, and that people go into our prisons one way and come out totally reformed and rehabilitated and ready to reintegrate into society. What we know from our experience is, in fact, that the experience of prisons is itself a trauma, and that people who are incarcerated experience such trauma, and that coming out of it, they are not people who are healed in any way. This is not a healing environment. And so I understand as a human being why we want to have a law on the books that says this particular behavior is bad. We don't condone this behavior. We think it's something that is not okay with us. So I understand why people would say, great, let's criminalize it, because it means that we're showing to the world that this is something that we don't condone. However, what the practical aspect of criminalizing something after the fact, and Pam and I were both at committee when they were doing the study, and so was Deepa, I believe. But Pam and I were there on the same day. And unfortunately, Pam didn't get all of the right questions that she should have, because they were asking for all kinds of evidence around intimate partner violence, and Pam is obviously the expert in that, and they were directing those questions to me, and I'm the expert in other ways. And so, I think that what happened in that room and what happened in the House of Commons is a political demonstration of doing something about an issue. So intimate partner violence and coercive control are issues. We know that. We talk about them as being, epidemic levels of, problem in our country. And so we all want to do something with them. And legislators think to themselves, what are the tools that I have to do something about it? Okay, maybe I can criminalize it. Maybe that's how we can move forward on this horrific act that we all agree is horrific, by the way. Like, I just want to underscore that. And despite us bringing forward, so much evidence that this is not going to have the result, that is going to be like oh, we did a good job, pat ourselves on the back, and then move forward. Where is all of the investment into community? Where is all of the investment into alternatives? How can we actually encourage people to take accountability and to change? Because our criminal law doesn't do that, and prisons definitely don't do that. And so how are we going to prevent people from being harmed in the first place? Isn't that what we should all be working towards? Not responding after the fact when all of this has happened. So yeah, I'll just stop there.
Yeah, this is, I really appreciate all of your comments and reactions. Anybody else want to jump in? Anything that's coming to mind?
I just wanted to go back to where you started, Angela. You started with, when we were framing of today's conversation, you said that Nova Scotia Mass Casualty Commission and the horrific incident that happened here, and the commission was formed. And the commission had series of recommendations similar to the CKW inquest recommendations that Pam just talked about. And one of the clear recommendation that is in, or the language which is in the commission's report, is which talks about that community-based and not a carceral approach should be emphasized, right? So Emily just talked about that. Like, where is the conversation about the alternates? Where is the conversation about what else are the options? And because the carceral approach is something that we have used, and we think that is what is keeping the place safe for specific populations, we continue to invest in those approaches, right? So we forget who those approaches do not save. We forget who are the people who are getting harmed the most. And I think I'm kind of repeating myself when I say that it's the most marginalized of the marginalized communities who do not get safety out of these provisions, right? And I think that's the challenge that I am always kind of thinking about, and the evidence that they had in front of them is the legislation that has been made in England and Wales and Scotland. And to be honest with you, as a very small organization that was invited to engage in this at, I think, before it went to the House of Commons, there was an engagement session organized. We did some research for that engagement session. Then it went to House of Commons. We prepared for that, and then there was this study which was being taken on, happening. So we have invested, from my perspective, for an organization that is main mission is to do frontline work, and we do law reform and advocacy work as part of that big picture thinking. I felt that we did a lot of good work of bringing evidence forward that even from England and Wales, the legislation there does not show anything that it has improved the safety of women and children in those jurisdictions either. So if you don't have evidence that it is making any changes there, you have recommendations from various commissions, including MMIWG, that there are so many things that can be done other than this. Why did people gravitate, or the lawmakers gravitated towards this? And I don't have, I don't have a crystal ball to say why from the perspective of what happened. Even the changes that Pam talked about at the beginning, the submissions that we made initially on the language that was, there was a lot of problems that we identified in the language that is at the second reading. There is so many changes. There's almost like a deconstruction of what a coercive control pattern can look like in relationships. Again, it doesn't capture everything that needs to be captured. But my question remains that other than that, it's a band-aid solution and it's a quick solution, and it gets you a tick mark on saying that we did the right thing. I cannot see if there is an evidence-based approach to it. And that is my point that I want to raise with all of you, that I think one of the things that lacks in our justice system mechanisms is evaluation and monitoring of our justice system. We don't actually track the cases, and we don't really monitor what is the outcome of all these new laws that get made. And there are few that in last 1 year, there are few things that have been amended and changed within the criminal code itself. And I feel unless and until we would push for or ask for a more evidence-based framework, all of these legal changes are not necessarily going to bring the outcome that everyone wants to see, which is more safety and end of gender-based violence. I'm not questioning that at all. So again, it's one of those situations where you're not questioning the intent. You are questioning why were they more convinced of the change as compared to the evidence that was in front of us, which all of us were presenting to them. One more piece, I think I did talk about credibility piece already, so I won't repeat it. But one thing that I feel is really important to understand is that any new offense does not get implemented unless and until the legal system actors are given the tools and acquire the right knowledge and sensibilities to apply it. I have seen, and I have given this example multiple times over, and many of you would remember, there was this omnibus kind of a bill which was brought forward by previous government called Bill S7, which was Criminalizing Barbaric Cultural Practices Act, if you remember. It was not even an act. It was one bill which was bringing changes in a lot of those acts. And so forced marriage was criminalized by virtue of those changes. And you can stop any police officer in any city in this country and ask them, do you know under what section someone can be charged for forced marriages? And I'm pretty sure that they would not know that. So unless and until our police officers are not really trained and they're not given the skills and the sensibilities, and they're not given the tools to effectively identify coercive control, no matter, even if there is, all these iota of the right intention, that right intention is not going to actually have any kind of outcome. Even if the outcome which they're looking for, there will be nothing done, because absence of that understanding means that coercive control will be another offense on the books. They would still have to register all those incidents separately, then cumulatively say, oh, this this can be coercive control. It will be a make work project, unfortunately, and I am waiting to see if it passes, which the chances are very high at this point, what would happen in the courts then, right? Because the evidence from England, Wales, and Scotland is that it is not really doing any favor. And in fact, there are very few cases that have proceeded successfully under coercive control. And even in those cases where they have proceeded successfully, they still go back to the incident-based approach to prove coercive control. And that, I think, is the mess that no one was ready to address throughout this process. And no one really wanted to unpack it. A last point, though, that is really important from my perspective. From the clinic's work, we have been looking at effective risk assessment tools to be placed in actually unpacking these experiences of coercive control, not only from the perspective of what are the risks, but also from the perspective of what are the identity factors or the social locations of the people, whether it's a Black woman, an Indigenous woman, a racialized woman, immigrant woman, and all of those gender diverse experiences. And I feel unless and until the system moves towards a risk mitigation process or risk mitigation skill set and thinks about safety planning in the processes, I don't think we can actually see the solutions that we need. And I agree with Emily when she said earlier, where is the safe housing? Where is the income support? Where is the counseling? Where is all of those other resources that are actually needed to end gender-based violence?
Mm-hmm. Yeah, that's fabulous, Deepa, and it makes me think about the National Action Plan on Gender-Based Violence, which I know many of us in this room worked on and are seeing it roll out in mysterious ways right now all across the lands. Reactions, comments, other things to say?
One of the things I'm finding sort of interesting in the conversation we're having this afternoon, I think we're about, what are we, an hour and 40 minutes into it. And other than one, I think it was Deepa, it doesn't matter who, one person once said the two words mandatory charging, we haven't really talked about it. And to me, this is a classic example of if we were doing evidence-based work when thinking about coercive control, we'd be looking at mandatory charging and we would not have a new law criminalizing coercive control. Like the push to criminalize coercive control, I think the intentions of those who brought in those policies were good. I mean, it was a different era. I think I'm probably the oldest one on this call, and I wasn't doing this work at the time that those policies came into effect. They made sense at the time, but we've seen the ways in which they don't work. And not only are they still on the books, but now we're making new laws without thinking, well, what about the last few laws we made, thinking that they would be helpful to women? Gosh, those didn't work out so well. Maybe we should be coming at this from a whole different direction.
Yeah, that's a good point. We just launched another poll here as we're coming into the stretch.
Gosh, I hope we've persuaded all that 60% to change their minds.
Well, what we wanted to do certainly was to, have the conversation and to get into these issues in the sense of like all these aspects that you've covered so well, because I don't think that we get to do that necessarily. We see the experiences of gender-based violence kind of presented through the media in general. Those of us that are doing this work, we get to have these conversations, but overall that doesn't necessarily, there isn't space for that. So this has been really important, this kind of critical thinking around it. Yeah, what do you think, Agnes, as you're listening and in your work and supporting survivors with family law?
Well, it's really amazing. I don't practice in the area of criminal law. I sort of, I do read up on these things, but how it actually plays out, I don't know. So it is really important, as Deepa says, like, we need to look at how it actually, what's the reality of what happens with these. And laws just on the books make us really complacent as a society. And we think, well, that's going to take care of it, and we've dealt with it and so forth. And so we don't have to deal with it anymore. But as everyone's known, there is a lot of implications. And that's why, for me, and I practice strictly in family law and in family policing law, child protection law, you can see where it comes down and it flows down there and the impact. And it may not, everything's subtle, right? it's not like judges are very specific about, well, actually, that's not true. I mean, I've read some really horrific things that judges will say about people, basically calling women just liars about everything. And you know that something's happening there. I mean, in family law, judges are very quick to talk about things, just high conflict. That's how they just sort of, essentially mask or try to minimize or mutualize anything that could be family violence, is just calling it high conflict. And they don't take that, and I don't think they have the skill, to be honest. I have great respect for judges because they do have a lot of smarts and things like that. But and it's really horrible. I say this to, I mean, Summerine knows this. I say, I'm a feminist, a longtime feminist, and I feel so anti-feminist working in family law. Because how many times do I have to tell women, you're not going to get a protection order. You don't have enough to show that, this is family, intimate partner violence, or this is coercive control. It's the most horrible feeling as a lawyer. And knowing what they are going through, but knowing that it's going to be very difficult to convince the court. And a lot of times in family law, and I believe this is in many jurisdictions, particularly in what's our Supreme Court, things are done by affidavit. So, you have and sometimes, certain people, men, whoever are educated, are more, can be, right in a particular way that is convincing. And it's really hard to get the subtleties of what's going on, particularly coercive control, about what is actually happening and what the impact is on you. You can say, he sent me 15 emails in a day. And it's like, okay, well, just block him. I mean, that's the solution, not like, what is that impact? And it doesn't happen every day, but it happens. And it's the fear that it could happen, right? And so we haven't figured out how to deal with that. And so having another law in the books is not going to help that. And I think I'm concerned, like everyone is, that women will get criminalized. It will be used against women, that more men will probably be like, yeah, fine, let's charge, let's make the complaint to the police about the woman being coercively controlled. And women sort of a lot of times it's like, they realize, what it's going to take if they go forward with that, the impact on their kids, the impact on themselves, trying to prove it, being again victimized again, and so forth, because women are used to how the state treats them. And so it can be a tool to oppress again. And that's, again, my concern. So.
Thank you. As we're coming near the end here, why don't we do a round to close? And if you'd be willing to, say some final words, final thoughts, and what you're looking ahead to in this moment, generally, and maybe in your practice. Maybe Summer, I'm going to put you on the spot and see if you'd like to go first to close. What you're looking ahead to, sort of what your comments and maybe what you're looking ahead to.
I'm not 100% sure what I'm looking ahead to yet. I definitely think that we need change and that we need new ways to approach intimate partner violence or gender-based violence or sexualized violence in all elements of the system that actually come from a trauma-informed, decolonial, anti-racial, maybe justice approach for survivors. But I don't know what that looks like yet, or how to achieve that in a system that is not built for that. So right now, I think mostly what I look forward to is ensuring that the survivors that we support and that are reaching out for services and support are able to get people like us who understand the nuances and the interconnection between the systems to maybe possibly affect better change in their circumstances. So that's me. And also, I have just very much appreciated being a part of the conversation and for meeting the panelists that I hadn't got to meet previously.
Thanks, Summer. Thanks, Summer. Who'd like to go next? Final comments and what you're looking ahead to.
I can go quickly. I hope it is quick. One, upstream investment is a huge marker of how society deems this issue as an important issue. So how are we going to be investing to prevent people from being harmed? That's a big thing for me. The other thing is one of the recommendations from the Mass Casualty Commission was to create an advisory committee of people who understand coercive control. I'm really hope that the government moves forward with that and has Pam Cross on it. That's the one thing that I really hope happens. And then lastly, I'm really curious about a defense of coercive control in women's lives where they have tried to fight back or defend themselves against what has happened over time. There's some very high profile examples of people who have for years and years endured horrific trauma. And then in the end, after seeking help wherever they could, ended up, either killing their partner or harming their partner. And so definitely we want to prevent that from happening in the first place by, having all of the supports in place. But where a person is, has experienced coercive control over time, is there a defense of coercive control that they could use when they've been charged in those circumstances? I'm curious about how that could play out.
Thank you. Who's next? Deepa, would you like to go next? It's like we lost Summer there.
I think I kind of already alluded to what needs to happen, but definitely what we need is we need survivor-centric approaches, we need trauma-informed approaches, but we also need integrated services, and we need legal empowerment and collective action to continue around this particular issue. Even if it becomes a law, then I think as the feminist advocates, we fight the law, and if it becomes a law, then we fight for it to be applied judiciously. Like that's what our job is, right? So I have signed up for both in my life, and I would say then that if it becomes a law, then let's put our energy behind making it more evidence-based and making sure that the policies that are created around it in the criminal justice system are actually appropriate for the survivors. I know that I commented on that, judicial education is part of the equation, but I would say it's not only the education, it's hiring the right judges. It's getting the people in judiciary who actually represent the communities. I think we need more Indigenous judges, we need more Black judges, we need more brown judges. We need people who know the communities and experience of the communities to be seen making these decisions, and hopefully that would create the ripple effect of the change that we need. Education is part of the equation, but it's not going to cut it. And then most importantly, I think we should not close our eyes to this reality that this is a complex problem and it needs complex solutions. So I am a big fan of Arundhati Roy, and I quote her all the time on this. She says, don't simplify what is complex and don't complicate what is simple. And the simple fact is that gender-based violence can be ended in our lifetime. Thank you.
Thank
Yeah.
you.
Totally
What-
agree.
Yes,
Thank you.
yeah.
I want to actually say, I want to put a brakes on some things in family law, particularly there's this whole notion that there's no presumption of shared parenting. Of course there is. And there's this whole notion that really the way to go is with alternate dispute resolutions, negotiate. I'm not opposed to ADR. I mean, I'm a mediator as well. But, we're moving towards very much where mediators say, whether there's intimate partner violence or not, doesn't matter. We can still mediate everything. And I think there's a danger that we're just sort of, in the family law, family violence it's just one factor of the best interest of the child. And it's just being pushed down, 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 I think. And that's what we need to make sure it's at the forefront again. And now, since the good thing about the bill, I suppose, is that it puts in people's heads, oh, coercive control, that's a thing. But we need to really it is a thing, and what it is a thing that it is. And so we need to be much more critical about that. For me, so we have to stop the complacency that things are going this way. We need to put it back at the forefront, intimate partner violence, family violence, and coercive control. So how do we do that? I don't know. I mean, I think as advocates and as lawyers, we need to raise it. We need to be brave and courageous and just do it, bring it up. But we also need to really protect and safeguard our clients because they're going to take the brunt of it. So we need to do as best as we can to really listen to their stories and understand what's going on for them, and to say, okay, how can we make this fit in the framework of this, judicial system so that they can get where they need to be.
Thank you. Thank you. Yeah, what do you think, Pamela?
I turned 70 last week.
Oh, happy
And
birthday.
that's not why I'm saying it. So I feel like I'm not done this work for sure, but I want to approach it really differently in the future. Before I started doing this work, which was like, let's say about 40 years ago, I was an activist, and I was an activist outside the law, trying to break down legal systems and structures that I didn't think worked for people. And then I spent this long period of time trying to make the law work. And I think that work has to continue. But speaking personally, I think I'm done doing that part of the work. I think we're going back outside. And I'm going to look at things like transformative justice, and look at, obviously, prevention. Yes, let's make it not happen so we don't have to figure out what to do after it does happen. But for me, coercive control was a bit of a turning point. Maybe it was partly where I'm at in my life cycle, but it was just the frustration from beginning to end that well-intentioned people didn't ask the right questions, didn't talk to the right people, and came up with a bill that, in my opinion, wasn't that great. It got a lot better through the process, but it was still the wrong solution. You can only do that so many times till you don't have energy to do that anymore. And I want to look at really, really transformative ways to respond until we don't have to respond at all. So I guess that's where I'm at right now.
It's very inspiring. Thank you. Thank you.
Maybe
And
I'm just tired. I don't know.
thank you. Very inspiring, everybody, and insightful. I just want to draw our attention to the poll. Yeah, it's interesting how well, the question changed a little bit about, do you think it'd make a difference? And the assumption is a positive difference for victims and survivors in Canada. And so it looks pretty evenly there in the sense of yes, no, and not sure. Thank you to all of the participants for sharing your questions. I know we didn't get to all the questions formally, but the panelists were covering lots of amazing topics and covered in general ways some of your questions. Thank you for taking the time out of your day to be here with us all. And yeah, it's been incredible to be with you all, panelists. Thank you so much, Emily, Deepa, Summer-Rain, Agnes, and Pamela, for sharing your wisdom and insights, and for all of your amazing advocacy and support for survivors and victims, your support for all of the system players, your work with government and with other advocates, government generally, and then with advocates. And thank you for just sharing that vision of intersectional feminism that builds in a decolonial frame, and to be looking ahead for what kinds of things we could be doing differently, and that this could be a turning point for us in different ways, and maybe we could try and make it a turning point, perhaps. And to my beloved colleagues, Lucy and Lonnie, who have been supporting in the background, thank you. I am so grateful for our time together. It's been outstanding. And we're going to send out an evaluation to everybody who registered, and I look forward to seeing your feedback. Yeah, I am excited for how we can continue pushing and helping to move the dial on oppression, the root causes, but also some transformative change, both in the legal system, but in the social justice system as well. And with that, I say farewell and good morning to those of us on the morning side of the clock, and good afternoon to everyone else. I don't know, Lonnie and Lucy, shall we jump on a phone call, or I don't quite know if we want to end this yet.
Yeah, I'm